All right, good morning.
Morning.
Welcome to oral argument session here at the 5th District Court of Appeal. The argument this morning is being live streamed on YouTube, so please keep that in mind. This is case 21-1061. If you have any electronic or noise-making devices, please go ahead and switch those to a silent or vibrate mode at this time. For the morning's argument, we're going to give 20 minutes per side. Appellant, you can reserve as much of that time as you would like for rebuttal. We will set aside generally as a default 5 minutes, but if you would like anything other than that, please simply let me know. Appellees, excuse me, which include Orange County and the individual plaintiffs, you also have 20 minutes for your side. Have you decided how you would like to, divide your 20 minutes?
Yes, Your Honor, this is Elaine Assad for Orange County. We did file with the court and receive permission for each of us, Mr. Dietz and myself, to have 10 minutes each.
Very good. And who's going to go first?
I will. Elaine Assad.
Very good. All right, counsel for appellant, if you're ready, you may proceed.
Ready, Judge. My name is Stephen Mason, and I represent Rachel's, the appellant. I'd like to begin with the issue of punitive damages. And the reason I want to talk about punitive damages is because the other side doesn't want to talk about punitive damages. Other than the employment lawyers, I don't think Orange County or Mr. Dietz have spent probably a sentence in their briefs talking about punitive damages. And the second reason I want to talk about punitive damages is I think it's the linchpin. It's the Roman capstone in many respects to this conflict issue. And it's a great segue into the administrative adjudicatory, the condition precedents under Chapter 760. And so if you look at the statute in this case, 760.11, the cap on damages for any discrimination lawsuit in the state of Florida is $100,000. That's the cap. And they use the mandatory shall. Orange County under 22-4 has eliminated, they've completely obliterated the cap. Now recently, give or take a month ago, you wrote an opinion on punitive damages. And you went through the entire elaborate scheme of punitive damages for those of us who aren't intimately familiar with punitive damages. And you talked about the gatekeeping role of punitive damages and that there's a certain procedural requirements that you have to allege punitive damages. Now imagine if you live in Orange County, where I'm sitting right now. I'm in Seminole County. My office on Hillcrest, 2 miles from the Orange County courthouse, is in Orange County. If you're in Orange County, the very next day after someone alleges that you discriminated against them, they can not only file a lawsuit against you immediately, they can send you a demand letter, claim punitive damages, scare the stuffing out of you that they're going to pop you for $500,000 or $1 million, and you're going to settle that lawsuit. We can get into a discussion about policies, whether it's a good idea to have caps. We can get into a discussion whether or not it's not equity oriented and that there shouldn't be a cap. But the bottom line is the purpose of Article 8, and the reason I spend a lot of time on the history of it, because I love history, is Article 8 is the impediment. It's the roadblock to keeping these cities and counties from passing local legislation that guts and that usurps state law. It's just a creative way of disintegrating or not abiding by a state statute that you dislike and that you want to eliminate. And that's exactly what's occurred here. In some respects, it's clever. In other respects, it's just an absolute sledgehammer that they've taken to it. So I don't think, if you ask them the question, Ms. Assad or Mr. Dietz, and ask them, have you eliminated the caps under 760.11, the $100,000 cap? They're going to have to say yes. Now, they haven't addressed this. The only entity, and strategically, I don't know why they filed the brief, I'll be honest with you. I mean, if candor is a virtue, I don't know why they brought in these employment lawyers to file the brief and tell you about how in love they are with filing litigation under Chapter 20 22 of Orange County's code and why sue under anything else. I don't know why anybody would file a brief and brag about how they're going to sue you and how that lawyers are going to have to defend these things in mass and how they're going to get all this money and how it's just more expedient. They don't have to go through Tallahassee and that you can lever people for the specter of punitive damages above $100,000. It befuddles me that they file that brief on behalf of the plaintiff's lawyers. So to begin with, I don't think it's debatable. I don't think a reasonable person can look at, I don't think they can juxtapose chapter 22 and 760.11.5, the judgment for the total amount of punitive damages awarded under this section to an aggrieved person shall not exceed $100,000. Well, we know under Article 8 that no
Mr. Mason, the first sentence of that paragraph says, in any action brought under this section. They're going to argue, aren't they, that they brought their action under the county code, not under 760.
Then why have Article 8? I mean, that's my, I'm not trying to besmirch the trial judge, but he has a fundamental misunderstanding of Article 8. If we're going to rewrite Article 8 prohibits them. I mean, there was a case, Emerson, just 12 months ago from the Florida Supreme Court that talks about. It's a case called Nichols in the last 18 months. There's a lot of litigation going on Article 8 right now, probably for a number of reasons that's indicative of what's going on in the country. But Article 8 is a prohibition. Any statute written by the Florida legislature on a subject, for instance, the PIP statute has a condition precedent. If you want to sue a cop in the state of Florida under 760.28, there's a condition precedent. If you want to sue a doctor, there's a condition precedent. You have to hire another doctor and you have to fulfill all these requirements. These all fall within the subject matter of discrimination. The same thing with PIP, same thing with libel legislation, the same thing with collection actions. If they cannot pass a law on the same subject matter that conflicts with state law, it's a bedrock principle of the US Constitution, and it's a bedrock principle of the Florida Constitution. Now, I understand why people want to do it. I understand why they want to be clever. I understand what, if the judge here, the trial judge number 2 was correct, they could obliterate every single state statute that they disagree with on that specific subject matter. They could simply, he refers to it as an elective benefit. You can participate or you cannot participate. That's not been the law ever in the state of Florida. Back to the 19th century, that was not the law in the state of Florida. When we first had our first constitution, I think in 1845 to 1888 to the amendments in 1968, they simply cannot do it.
Mr. Mason, can you talk to us a little bit about the length and width of the field that we're dealing with here? Is your argument that the Florida Civil Rights Act preempts the ordinance in its entirety? Or is your argument simply that when it comes to the exhaustion of administrative remedies, and then when it comes to things like you're talking about now with punitive damages, that those are preempted specifically because of Florida Statute 760.11? What is the boundaries of the field that you think is preempted? Does that make sense?
Yes, makes perfect sense. I'm forthright by nature. I just cannot help myself. I mean, my argument is divided into 2 parts. The first part is conflict, inconsistency, contradictions, whatever word you want to use. I think Article 8 uses the word inconsistent with general law meaning state statutes. So the principal argument is in conflict because they've eliminated probably a third of Chapter 760 by eliminating every aspect of 760.11, which, by the way, I think is probably, you can correct me if I'm wrong, I think it may be the most comprehensive condition precedent statute in all of Florida law. I mean, I told you I looked at medical malpractice, I looked at PIP legislation, I looked at libel, I looked at sovereign immunity. There's a thread of condition precedents that run through Florida law. I don't think there is a more comprehensive process that you have to go through other than discrimination in the state of Florida. So to answer your question is, my primary argument is conflict under the punitive damages and conflict that they have gutted. I mean, gutted isn't even the right word. They've excised it. You know, they've just taken scissors and eliminated all of 76011, which they absolutely cannot do. And my fallback or my other argument is the bigger, broader argument that they cannot pass any law, not any law, even on the subject matter of discrimination in any form, even if they rewrote Chapter 22 and put in there explicitly, you got to comply with 76011. We got to fix the punitive damages. It could not be severed. I don't think they can pass anything. And that no court in the state of Florida has ever addressed this issue. If we're going to be intellectually honest, no court has ever done it. I mean, I call it, after reading that case from you, I call it the Fields BMW case, because every case they've cited, not on conflict, but on preemption, they say, look at this case. Here's a case in the 3rd DCA. Here's a case in the Florida Supreme Court. They mention in passing, they think these local boards exist, et cetera. In all of those cases, if you go back and even look at the briefs, I went back, I am so retentive and I'm so history oriented. I went back and pulled the briefs on boroughs from the Florida State Archives, had them ship them to me, and I read them, and even the amicus briefs that were filed in boroughs, just to show that these issues weren't litigated. I mean, it's in that Fields BMW case, they said, well, you weren't as harsh as I am, but you said essentially when lawyers come up and they make arguments to us and they say, 3rd DCA said this, and when we read that case, all we see is the court repeating the position of the parties or the acquiescence of the parties. That's not an adjudication. So on preemption, this is it. This is it. If you want to allow them to do it, tell them they can do it. And I know exactly what's going to occur. But on conflict, and I am absolutely utmost sincere, it's not debatable. They have eliminated both of those substantial requirements of Chapter 760. They cannot gut 76011. They just cannot. I mean, you cannot eliminate that entire segment of a statute and claim that it's somehow constitutional anymore. You cannot eliminate mandatory penalties. I'm sorry.
Mr. Mason, what's the purpose of the condition precedent generally in those other statutes that you looked at? You talked briefly about medical malpractice, PIP, and what evidence do you have that the purpose of the condition precedent in 76011 is consistent with the general purpose that you find in other conditions precedent that are in other state statutes?
That's a similar question that Judge Ashton asked. And I remember I said to him at the time, and I said, if you want to give me 5 days or you want to give me 7 days, I'll write a brief on it, because I am positive. In fact, I went back, there's a case from the federal 7th Circuit Court of Appeals that talks about the history of administrative remedies and why Congress has enacted them. In large part, it's for the following reasons. One is, as lawyers, I know it's hard to believe, the court system is full of garbage. There's a lot of lawyers that file garbage simply to get settlements from people. And we can be demure, we can be polite, but that is the reality. They file these things, and if it costs $100,000, I mean, I'm being paid by the hour as I'm sitting here, and so, if candor is a virtue, if it's going to cost the client $50,000 or $100,000 to litigate, and someone says, just pay me $40,000 and I'll take away your pain, I will take away your pain, and this lawsuit will go away. People will pay it. That's one of the reasons that 76011 exists, because 76011 is more than just a condition precedent. It is an investigative and adjudicatory. It is a complete adjudication of that particular lawsuit. They have a statute of limitations. They have to file it. It has to be reviewed and administered within 6 months. And then they have to have a right to sue letter before they can even go to court. I mean, in Stacey McLean, you went into great detail, because the rules of civil procedure written by the Florida Supreme Court, they state, or the Florida Supreme Court stated, if your statute or your claim involves a condition precedent, you have to allege it in the lawsuit. You have to allege it. That's your burden to allege it. And then when you go in front of a judge or jury, you have to prove that you satisfied the condition precedent. And if you haven't, your lawsuit gets kicked. Stacey McLean, they alleged it, went to trial and won right here in Orange County. And then on appeal, you reversed it and said condition precedents are so powerful. They're so important. They're not subject to debate. They're mandates. You did not fulfill the condition precedent, and that lawsuit brought by Mr. McLean was reversed and remanded with directions to dismiss and enter a directed verdict. And you went into some nice history. In fact, looking at Stacey McLean, you cite cases from the first DCA, the second DCA, the Florida Supreme Court in Joshua. You go through all of it and explain why conditions precedent are so powerful and why they have to be alleged and why they have to be proven.
Mr. Mason, can you address the fact that these ordinances have been around now? They've been in existence for a number of years, and the Florida Civil Rights Act has been amended by the legislature since these ordinances have been in existence. And the legislature, it doesn't appear, has addressed these ordinances and any of the alleged conflict or preemption. Are we supposed to take anything from that?
I'd answer it in two ways. If you look at the history of these ordinances, you're going back to the 80s, because I think originally we had chapter 13, we went to chapter 760, give or take 1980. Originally, all of this were, these boards that were created at the local level were, they would make recommendations, they would conduct investigations. This ordinance we're talking about here is relatively new. Chapter 22 was passed, give or take 2010, 2011. This litigation was brought in 2017. And when I read it, because I've been involved in a lot of Article 8 litigation, as soon as I read it, it seemed to me that they were rewriting and usurping state law. And I brought the motion to dismiss. There was no answer. And so this idea that they can create causes of action and they can eliminate anything in a state statute they disagree with, that's dangerous. So I divide your question into two parts. So on that conflict issue of the causes of action, eliminating anything in a state statute you disagree with, this is an absolute winner, not just for my client. My client is actually doing the heavy lifting for all these other poor businesses in Orange County and across the state of Florida that are being manipulated by these terrible, terrible local laws and legislation. It is constitutionally offensive. I can't even stress how much it bothers me that people are paying settlements on this when they never even went through Tallahassee and exhausted their administrative remedies. Now to answer the second part of your question on preemption, I understand that. And candidly, I think that's a better argument for them because they can say, look, we've got a history. We started off with these boards in the 70s and the 80s, and they went along and they've existed. And the court has made statements that would indicate or that they exist, and we acknowledge that they exist. I understand all of that. But the bottom line is no court on the question of preemption, meaning can they even pass an ordinance on this subject? And whereas conflict is, yes, you can pass an ordinance on this subject. We find it's not preempted, but you cannot pass an ordinance on this subject that eliminates requirements of state law. I mean, the case that came right out from you, the 5th DCA, and Judge Harrison, your father wrote the dissent in Carl Leroy Thomas. That was an en banc, big, powerful, political case that ended up right in the lap of the 5th DCA, where the court was divided, I think 8-3 or 7-4, something like that. And Charles Harris wrote the dissent and said, you, Orlando, you wrote a law and you have changed the requirements of state law. You cannot do that. That has been prohibited for 100 years in the state of Florida. And Judge Harris lost. He was on the losing end. I think Jackie Griffin wrote the majority. That went to the Florida Supreme Court, and Judge Harris's dissent became the majority view in a 6-1 opinion of Thomas versus State, which involved an Orlando ordinance where they were trying to rewrite state law, trying to rewrite penalties, and it was gone. The same thing with Demings. You authored Demings, and Demings was the same thing where Orange County, just like Singh versus Orange County, in Demings that came before you in like 2016, They created a local board, and the local board said, we're going to subpoena cops and we're going to interrogate cops and we're going to put them on trial of sorts. And this court said, no, you're not. There's a state statute that says there's going to be an investigation internally against a police officer in Demings versus Orange County. State statute says it's done by the Internal Affairs Division. It's not done by you. You don't have the authority to do that. That went up to the Florida Supreme Court in a case called D'Agostino, and they agreed with the 5th DCA and disagreed, I think, with the 3rd DCA and said, you're wrong. You cannot rewrite state law on the same subject.
Mr. Mason, you've got under a minute for your rebuttal. Would you like to save what's left?
Yes, sir.
All right, thank you, sir. All right, Ms. Assad, you ready? You may proceed. Hit your mic.
Thank you. May it please the court. My name is Elaine Assad, and I represent the appellee, Orange County, Florida. I will argue the issues of conflict and preemption. My colleague, Mr. Dietz, will argue historical analysis, public policy, and the development of the Florida Civil Rights Act. Again, the court, we have agreed to split our time 10 minutes each. This case concerns the constitutionality of Orange County's Human Rights Ordinance, Chapter 22 of its code. The essence of Mr. Mason's argument is that the only recourse for a person experiencing discrimination is to go through Chapter 760, and that the Florida Civil Rights Act impliedly preempts the field as the scheme of regulation is set forth in Section 760.11 through its detailed pre-suit administrative process.
Ms. Assad, let me ask you this, and I'll ask Mr. Dietz the same thing, but at least he's mentioned the case in his brief. You don't talk about the Joshua case one time in your brief. In Joshua, doesn't the court say we conclude the legislature wanted persons who believe they've been the object of discrimination to go through the administrative process prior to filing a civil action?
Yes, but I believe, Your Honor, that is if they file suit under the Florida Civil Rights Act. And I think when the court looks at all the case law that is before it and that has come before the courts, it says that if you file a suit under the Florida Civil Rights Act for discrimination, you must follow the pre-suit administrative process. But I think when the court looks at the statutory language as a whole, you will find that it does not preempt or does not forbid local legislations from enacting ordinances for anti-discrimination, such as when you look at the Florida Civil Rights Act, it has as an example in 760.07, it recognizes under that statutory language that some anti-discrimination statutes may in fact omit the pre-suit administrative requirement, such as the HIV/AIDS discrimination statute set forth in 760.50 and the Florida Educational Equity Act set forth in section 1000.05. So when you look at that language, coupled with the entire language of the Florida Civil Rights Act, you find that there is not, that the pre-suit administrative requirement is not mandatory outside of the Florida Civil Rights Act. In fact, it also provides that litigants, when you look at that you can proceed under other statutes or under other ordinances, you can proceed to litigate discrimination cases that is not forbidden by the language of the Florida Civil Rights Act. It also has provided that to pursue a private cause of action, you can do so without the necessity of providing a pre-suit administrative analysis. Now, I know Mr. Mason's argument is that by failing to include a pre-suit administrative requirement in the ordinance that we have gutted the Florida Civil Rights Act, but that's not true. Also, if you look at the other language in the Florida Civil Rights Act, as an example, under section 22.41 of the ordinance, Orange County's ordinance, you find that it defines places of public places of public accommodation to include bars and taverns, hospitals, and professional offices. In the definition of the Florida Civil Rights Act, those are not included. So additionally, if you look at under section 760.11, what can you sue for for discrimination? It does not include age, marital status, or sexual orientation as is included in the Florida ordinance.
But Ms.
So-
Assad, isn't that a question of what classes the statute gets applied to as opposed to what regulations they oppose? Aren't we looking here at the requirements that are imposed by the statute versus the requirements that are imposed by the ordinance, and not simply, this case doesn't involve different classes? Wouldn't you agree with that? And how would you address that question? That
I think, Your
distinction?
Honor, sorry.
I'm sorry, go ahead.
I do think, however, putting aside the language of the ordinance, when you look at the language of the statute, when it defines places of accommodation, if, as an example, you're in an office building and you experience age discrimination, it is not included in the definition of being able to file under places of public accommodation, because places of public accommodation are generally restricted to places of entertainment, places of lodging, and so forth. And so when you look specifically at the language, it does not include all types of discrimination. It doesn't have a general clause within it that says, gee, if you're in a place of public accommodation and you experience age discrimination, you cannot file suit under the Florida Civil Rights Act for discrimination in places of public accommodation. And the case—
But does that, I'm sorry, Ms. Assad, does that affect his conflict argument, though? I understand the argument as to preemption, but does that affect the conflict argument that Mr. Mason's making?
Your Honor, when we look at conflict, you look at what is the, whether you have to violate the provision of, a provision of the statute in order to comply with a provision of the ordinance. And you don't in this particular case, because it is, they are addressing different issues. And it doesn't conflict because you don't have to violate the Florida Civil Rights Act, because you're not filing under the Civil Rights Act, rather you're filing under the local ordinance. It doesn't conflict. It's not, the pre-suit administrative requirement is not mandatory outside of the Florida Civil Rights Act. And you can proceed under the local ordinance.
Mrs. Assad, I want to ask you the same question I asked Mr. Mason. And I'm sorry if did you have more to say on that point?
No, go ahead, Your Honor.
What do you think the purpose of the pre-suit requirement or the condition precedent or the exhaustion of administrative remedies, what do you think the purpose of that is in the statute?
That is to have the Human Rights Commission take a look at whether or not the claim for discrimination falls within the Florida Civil Rights Act, and that which you can, if there's enough evidence, if you can file suit under that.
Mr. Mason contends that it's a protective measure. I think that's similar, and he cites the case D'Agostino. What do you say to the fact of his argument that the exhaustion of administrative requirements or the requirement that you have a reasonable cause determination? What do you say to his argument that that's a protective measure?
Well, it is a protective measure if you file under the Florida Civil Rights Act, but there's nothing, when you look at the language, and I go back to this argument, when you look at the language as a whole of the statute, it doesn't say you have to file under the Florida Civil Rights Act if you experience discrimination. That's not what it says. It's limited in its scope. It's limited in its classification of the types of discrimination that fall under the statute. And for those reasons, we don't believe that the exhaustion extends beyond a case that is filed under the Florida Civil Rights Act. I believe Judge Wozniak mentioned earlier that there has been a history of challenging and changing the Florida Civil Rights Act. And there's a series of case law which the court has before it in all the briefs that have been filed. Never once have they clarified or sought to provide a provision that says, we reserve this field to the state, and all claims have to be filed under the Florida Civil Rights Act. So we do not believe that Orange County's ordinance conflicts or is preempted by the Florida Civil Rights Act. I do just want to mention, because I see I only have 24 seconds left, if the court finds that the cap, that the ordinance cap is improper and conflicts with the state rules on punitive damages, then we would ask that if the court is going to strike any part of the ordinance, that it can strike that portion, and Orange County can go back and amend that to include a cap on punitive damages. But it does not mean that the remainder of the ordinance is unconstitutional. Thank you.
I do have one question, and it can either be from Ms. Assad or Mr. Dietz if you want to toss it to Mr. Dietz, Ms. Assad. But can you tell us another claim that a person can bring under a statute and then a similar claim under an ordinance where the procedures are different and the remedies are different?
Mr. Dietz?
And it has been allowed to stand? You're on mute, Mr. Dietz.
Yes, absolutely. This exact thing occurred in SPV. Hope versus SPV, which is a third DCA decision approximately 3 years ago. In that case, what happened is the claims were brought under the Florida Fair Housing Act and not the Federal Fair Housing Act. At that time, the Florida Fair Housing Act had a required condition precedent. It was a must. It was not a may. In that case, the appellants in that case urged the court to say that this must be done identically. The two statutes are interpreted in pari materia. The third DCA said no. In order for we have to interpret the Florida Fair Housing Act to require a administrative precondition, and the state doesn't. So as a result of that, within 2 years, the Florida legislature in 2020 amended the statute, amended chapter 760.23 to say that the condition precedent was not mandatory because the inclusion of the word must. So that is an exact thing, but to go on to Judge Nardella's question about why would somebody do one and then the other? And the Supreme Court of the United States in the Gladstone case addressed that exact point, and that is a 1979 Supreme Court case, because they had the same issue with the Fair Housing Act. Because at that time, in 1979, the Fair Housing Act not only dealt with an administrative condition where you had to go through this extraordinary, actually much longer than the FCHR process, but actually the FCHR process was modeled after that, because FCHR is an agency that is a deferral agency for HUD. But be that as it may, when they did that, the position was you must go through administrative preconditions, and the Supreme Court said no. And that's on page 103 to 104. In that it said it is not structured to keep complaints brought under it from reaching the federal courts or even to assure that the administrative process runs its full course. Section 810B appears to give a complainant a right to commence an action in federal court, whether or not the Secretary of HUD completes or chooses to complete conciliation efforts. And the reason why is it gives the people an option. And as a practitioner, I could tell you why. Number one, the victims in this case, who I represent, Anita Giannis and Brittany Smith, they didn't want to wait 180 days until a decision came out to continue the discriminatory practice. If this was a race case, and as Mrs. Assad was saying, stores are not included under FCHR, they would have to wait 180 days to file under the administrative preconditions to be able to get into a store. The purpose is for somebody to go in and say, discrimination is wrong. You don't have to wait. You don't have to sit around. You don't have to go through administrative conditions. And then if you lose on your administrative conditions under the FCHR, you don't have a private right of action. You have to go through an administrative hearing to determine whether or not you have a private right of action. If they make a determination within 180 days. So you may have at least a year, if not more. And that's also if the budget decides to adequately fund FCHR so they have adequate investigators to investigate charges, which often happens as well. So when you look at it, you're looking at two different remedies. Now, why would someone go through the FCHR if it's not a frequent occurrence? Number one, I'm going to an amusement park. I came in from Alabama. I'm not going to go to the amusement park, but I've been injured. It doesn't matter. You could wait 300 days to get your decision. So that is the purpose. And why is that done? And I apologize if I'm going too fast. And please feel free to interrupt me, which I know you probably will. But the Florida Fair Housing Act was not promulgated until 1992, which was well after. The public accommodations provision was well after all of these local ordinances had been promulgated. As to the purpose of the statute itself, in 760.01.3 was intended to be a liberal purpose. And then if you go to 760.07, which is the seminal statute in this, it says straight out that it contemplates other actions. And it says, if you want the relief as stated in this section, you must go through administrative preconditions explicitly. So we're not asking you to read something new into the statute. We're asking you to interpret it pursuant to legislative intent in that statute itself. Now, when you look at the history of this, and you look at the controversy that we've had as a state, dealing with Ruth Shack, gay rights, the gay rights ordinance, these were things that were heavy on the mind of the legislatures at that time throughout. There's always been other counties that have wanted to express the will of their people and say, you may not do this in our county. And there are many counties and municipalities in Florida that don't, that have the basic bare bones protection of the Florida Civil Rights Act.
Mr. Dietz, Chapter 760 contemplates the creation of local commissions, that local governments will create commissions. Does Orange County have such a commission?
Yes.
And what does it do?
It is the one who investigates these types of claims. So you have commissions in many counties and municipalities that investigate civil rights claims, whether they're fair housing claims, whether they're public accommodation claims, whether they're employment claims.
So does the statewide commission delegate to the local commission to investigate it, or what claims are they investigating?
The statewide, they do both. They may have contracts with local commissions to do this type of work. They may have contracts with the federal government, HUD or the EEOC, to do this type of work. And they may also do their own internal work with regards to their own issues.
But they're not involved if a claim is brought under the Orange County ordinance. They're not involved in that.
Yes, they are. They do. They investigate. Depending on the commission, they investigate all three: federal, state, and local. But it doesn't. Their investigation does not delay the bringing of the claim under the ordinance. No. And similar to, the Fair Housing Act the Florida Fair Housing Act goes as far as you can bring a claim in court up to the point the administrative judge starts the trial. So even if you look at discrimination cases, and Mr. Mason says all discrimination cases can be covered. If we just look, I listed about 20 of them, from the Ninth Judicial Circuit discrimination cases to any other thing that he believes that should be within FCHR that's not. But even if you look at Chapter 760 itself, you have the Florida Fair Housing Act that requires administrative condition for employment cases like the EEOC does. You have the Florida Fair Housing Act that does not require administrative conditions as to 2020. You have the restricted private club provision that requires a different type of administrative provision. And then you have the Florida Omnibus AIDS Act that requires no administrative conditions. So in the same statutory scheme, you have 4 different administrative precisions or none. Thank you, Your Honor, and I would respectfully request that this court affirm the lower court's decision.
Thank you, Mr. Dietz. All right, Mr. Mason, you have a little bit of time left for rebuttal.
Body of my 48 seconds, unless you give me a minute and a half, I want to make 5 quick points. One is there was no administrative review in this case of any kind. He filed that lawsuit as fast as he could print it off the hopper and file it. Number 2 is the reason he did that is, he's well-spoken. He's eloquent. They have lobbied these local governments to obliterate state law. It's like little fiefdoms. We're going back into time like Henry VIII, and they're creating their own little fiefdoms, and they're eliminating anything they don't like, and they know it. Number 3 is, I never read a Hope versus SPV case in my entire life. And I'm conservative by nature and I'm frugal by nature, but I'll bet $5 that's not an Article 8 case, because no court in the history of the state of Florida has or will ever author an opinion and state that a local government can eliminate a mandate or requirement of state law. We would have chaos in the United States. We'd have chaos in Florida if we let them eliminate anything they don't like.
All right, Mr. Mason, I gave you the extra 30 seconds you asked for. So that's it for your time. Thank you all very much. Case very well argued by everybody. And at this time, we'll be in recess. Have a great day.
Thank you, Your Honors.